All stand, please. Sit, please.
This is an application made out for leave to appeal from the judgment and orders of Mr Justice Dixon given and made here on 19th February 2013. Facts of the matter are lengthy, but we shall endeavour to state them concisely. On 15th November 2011, the Victorian Civil and Administrative Tribunal made an order under section 323A and 245 of the Residential Tenancies 1997 requiring the applicant to vacate rented premises of he was then in possession. The application sought, quote, a rehearing of the possession order, but on 17th November 2011, Ms Day, member, rejected his request for rehearing. The applicant sought leave to appeal from the possession order, but on 29th November 2011, the judge in the practice court refused leave, and on 4th February 2012, this court dismissed an application for leave to appeal from the order of the judge in the practice court. Having so failed in his attempts to appeal against the possession order, on 3rd April 2012, the applicant attempted to file in the anti-discrimination list of VCAT application, presumably under section 124 of the Equal Opportunity Act 2010, for relief against the Attorney General and, quote, the Department of Justice, close quote. The application alleged that the applicant had been discriminated against on the basis of disability, employment, activity, gender identity, physical features, political belief or activity, race and sex, and that he had been victimised, racially vilified and subjected to prohibited requests for discriminatory information. Under the heading of, quote, what happened, close quote, the application stated that 1. J. Kefford, strikeout medical report of chronic condition. 2. G. Nile, continuously providing legal advice to respondents. 3. VCAT registrars, question mark, colluding with slumlords in illegal eviction. 4. VCAT continuous harassment and victimisation of myself. 5. I believe this is based on race. 6. I believe that this is based on my making application against Vic Police. 18th April 2012, Principal Registrar of VCAT wrote to the applicant rejecting the anti-discrimination application pursuant to section 71 subsection 1 of the VCAT Act on the basis that VCAT had no power to hear the application or grant the relief which was sought. On 24th April 2012, the applicant applied pursuant to section 71 subsection 2 of the VCAT Act for a review of the Principal Registrar's decision to reject the anti-discrimination application. 4th May 2012, Ms Day, member, sat to review the Registrar's decision to reject the anti-discrimination application. In the course of the review hearing, the applicant submitted that section 24 and 39 of the Charter of Human Rights and Responsibilities Act 2006 entitled him to make the anti-discrimination application because the Attorney General and the Department of Justice had not been, quote, effective, close quote, and, quote, had failed to monitor their employees at VCAT, close quote. While while Ms Day was considering her decision, the applicant sent to her uninvited written submissions in which he contended that members of the VCAT had acted, quote, not in good faith, deliberately and racially profile, and breaches of section 10 of Charter, close quote. On 13th June 2012, Ms Day published her decision and made orders confirming the Registrar's decision. Day held that the applicant was not a person who was entitled to make the application, thus that it could not be said that the duty created by section 38 subsection 1 of the Charter had been breached. The applicant later complained that although he had been present during the hearing of the review before Ms Day, he was not present when Ms Day made orders. On that basis, he sought to have the orders reopened under section 120 of the VCAT Act. The applicant was apparently also refused. On 11th July 2012, the applicant filed an originating motion and summons in the Trial Division, which named the Department of Justice and the Attorney General as respondents. In that application, he sought the following orders. A. Order made at VCAT on 30th June 2012 be set aside and or struck out. B. Cost order to be made in favour of the appellants. C. Seeking a declaration of unlawfulness and associated relief, including an injunction, a stay of proceedings or exclusion of evidence. D. Under Victorian Charter for Human Rights and Responsibilities Act 2006. E. Equal Opportunity Act 2011. F. Whether a question of denial of procedural fairness or natural law. A. A breach of natural justice. B. A breach of human rights. C. A breach of anti-discrimination and vilification legislation. D. An error of law. And or E. A failure to take into account a relevant consideration. G. Administrative Law Act 1978A, writs of mandamus for cruel and inhumane treatment of a person with a disability. In an affidavit of 11th July 2012, sworn in support of the application, the applicant deposed to the effect that he was aggrieved by the possession order and his day's refusal to consider the registrar's rejection of the discrimination application, inasmuch as they amount to a violation of his human rights. On 30th July 2012, the originating motion came on for case management mention before Associate Justice Zammit. On that day, the applicant swore and filed a second affidavit in support of the application. Stated that, quote, I have the, quote, copies, close quote, of the order and statement of reasons from Member Crimean that the High Court of Australia requested for leave to appeal Exhibit 2, close quote. Exhibit 2 was as follows. 1. Further to my previous request. 2. I seek an urgent application before the President of VCAT for all my matters. 3. I seek that the President of VCAT take over presiding over all my matters. 4. This is because I have a High Court application challenging the integrity and independence of VCAT to hear my cases in a fair and 5. Due to the fact that Deputy Presidents may have been at VCAT so long that they may not have taken any oath of office. 6. VCAT is conspiring to pervert the course of justice and depriving me due process by me rehearing pursuant to the VCAT Act. 7. Or denying me proper directions and denying me access to documents and evidence under procedure of documented. 8. At 11 a.m. on 25th July 2012, the High Court Registrar Mussolino rang me to ask for the decision and reasons for a possession order from Member Crimean. 9. I've asked for this repeatedly and VCAT has refused to provide it. 10. Please send it to me as soon as possible. Member Wentworth has a copy of it in a recent file, the numbers of which. The applicant also alleged in the second affidavit a, quote, conspiracy to pervert and deny myself access to the VCAT Act under their discrimination and harassment, close quote, and referred to a newspaper report of a statement by the Premier of Victoria as to possible future amendments to the Charter. At the conclusion of the hearing, Associate Justice Zammit held that it was doubtful that the application as then constituted raised a prima facie case, and Her Honour granted the applicant leave to file an amended originating motion. Pursuant to that granted leave, on 24th August 2012, the applicant filed an amended originating motion, which he identified the relief which he sought as follows. A. This is an appeal pursuant to Section 148 of the Victorian Civil and Administrative Tribunal Act 1998, and B. Section 39 of the Charter, or in the alternative C. Section 3 of the Administrative Law Act, and D. Section 39 of the Charter, or in the alternative E. Section 39 of the Charter, or in the alternative B. Order made at VCAT on 30th June 2012 by Member Day to be set aside and or struck out. D. Cost order to be made in favour of the appellants. D. Seeking a direction of unlawfulness and associated relief, including injunction, and I interpolate otherwise in accordance with the relief as sought. On 24th August 2012, which was 3 days before the day appointed for the hearing of the amended originating motion, the applicant filed a third affidavit in support of the application. In it he sought leave to rely on 3 medical reports of a Dr. Tang, a broad range of unparticularised allegations of conspiracies to deny him his human rights, as well as of denial of procedural fairness, discrimination, harassment and bullying, bad faith, and conspiracy to pervert the course of justice. 7th August 2012, the amended originating motion came on for hearing before Her Honour Associate Justice Lansdowne. Thereupon the applicant sought an adjournment of the hearing which he had foreshadowed in his affidavit of 24th August 2012. Associate Justice Lansdowne refused the application for adjournment, dismissed the originating motion for reasons which Her Honour expressed thus. 1. In relation to Order 1, the plaintiff has not demonstrated any basis for adjournment. No medical evidence is produced to support his assertion that adjournment is sought on medical grounds. Further, the application is made without notice to the defendants, and the proceedings have already been adjourned once. 2. In relation to Order 2, the amended originating motion was served and has been treated in argument as filed. 3. In relation to Order 3, the following is a brief summary of the reasons given orally. 4. In the relief sought by way of appeal pursuant to Section 148 of the VCAT Act, leave to appeal is refused. No draft notice of appeal is filed, and the amended originating motion fails to disclose any question, let alone an arguable question of law, articulated by reference to the decision of Member Day and the facts there in question, opposed to general questions posed in the 5. The Court accepts the submission of the defendants that there was a remedy available to the plaintiff if he wished to challenge the decision of Member Kerford and Neil, grounds set out in his proposed application to VCAT, by way of an application for leave to appeal from their decisions to this Court. 6. If the relief is sought by way of Section 3 of the Administrative Law Act, and the decision maker is Member Day, then no prima facie case for relief is shown. The defendants made no decision that could be the subject of relief under Section 3. The third basis for relief identified in the originating motion, Section 30 of the Charter, does not afford a standalone right to relief. A claimed breach of Section 38 of the Charter can only be relied upon in proceedings for relief, otherwise properly instituted. Reason of paragraphs 4 and 6, there are no such proceedings here. In relation to Order 4, the plaintiff did not oppose the making of a cost order to be excused and left prior to the termination of fixed after being given an opportunity to address quantum. Close quote. On 4th September 2012, the applicant filed out of time a notice of appeal from Justice Lansdowne's order pursuant to Rule 77.6 of the rules. It included an application under Rule 77.6.7b to rely on a further affidavit in support of the appeal. 13 September 2012, the applicant filed the further affidavit. Substance of it was directed to the conduct of the matter before Associate Justice Lansdowne. 26 September 2000, the appeal came on for hearing before His Honour Justice Dixon. His Honour dealt first with the applicant's application to rely on the further affidavit of 13 September 2012, and after hearing argument on the point, His Honour refused the application for reasons which I'll set out in the settled reasons for judgment of court, but which in substance were that because it was directed to matters before us, because the hearing before His Honour was a hearing de novo, it was irrelevant to the matters in issue before His Honour. The judge then turned to the substantive appeal. After hearing argument, His Honour reserved his decision. On 19th February 2013, His Honour gave judgment dismissing the appeal for reasons which it will be appropriate to set out verbatim in the settled judgment, including there what is said by His Honour in his reasons for paragraphs 29 inclusive. 5th March 2013, the applicant filed a summons seeking leave to appeal against the judgment and orders of justice. On the same day, he swore and filed an affidavit to which was exhibited a draft notice of appeal stating inter alia that this is an appeal against an order made by Justice Dixon on 19th February 2013, application under the Administrative Law Act for relief or remedy in the nature of mandamus and or prohibition, or in the proceedings for a declaration of invalidity or an injunction in relation to the order made by Justice Dixon, A, as an abuse of process, B, an abusive position of public, C, in order to vilify Aborigines and refugees, D, and inciting racial hatred, E, as breaches of the Victorian Charter for Human Rights and Responsibility. I, Lee Tuan Pham, seek these orders and remedies. A, that the orders and reasons of Justice Dixon be struck out, competence and a breach of the Charter. B, remedy by way of mandamus or appeal, and the coordinator for self-representation. D, remedy by way of prohibition on Aborigines and refugees on false. D, remedy by way of prohibition on Justice Dixon by failing to act conscionably. It was also exhibited to the affidavit what purported to be a notice of constitutional removal of the matter to the High Court and a quote notice to the Attorney General of the Rights Commission, close quote, if sought under the Charter of. Surprisingly, perhaps none of the other states' Attorneys General or the Commonwealth Attorney General had responded to the notice of constitutional and Rights Commission, His submission before us this morning, the applicant was unable to reach the claims of discrimination and breach of natural justice or Justice Dixon, stating that Justice Dixon had Justice Lansdowne rehearing de novo. So far as the applicant seeks leave to appeal from Justice of the applicant's eye on the affidavit of Thurl, consider that the application should be dismissed because reasons for refusing leave to rely on the affidavit. So far as the applicant seeks leave to appeal from the judge's dismissal of the applicant's appeal from Justice to grant leave to appeal, under that leave should be refused, the appeal would be bound to fail. We agree with Associate Justice Nation. The amended originating motion does not disclose any rational ground of appeal, still less any arguable question of law, and thus we agree with the Honour's conclusion that it's appropriate that the claim be dismissed. As far as the applicant seeks to review VCAT's decisions under C of the Administrative Law Act on the ground of lack of jurisdiction or denial of procedural fairness, we agree with Associate Justice Lownvan and Justice Dixon was appropriate if indeed their honours were not bound by Section 4, subsection 4 of the Act. Refuse the application, failed to make out a denial of natural justice. Justice Dixon observed the applicant's affidavit of 11th July 2012 shows the existence even of a possible lack of jurisdiction, denial of procedural fairness. Most of it can be gleaned from its contents. The applicant is so dissatisfied with failure before VCAT, deems it appropriate to make allegations of racial, sexual and other diverse forms of discrimination against the several judges who have had to deal with the matter. Not consider that the purported sections notice or the notice to the Attorney General and Victorian Rights Commission changes noted, apart from the Victorian Attorney General, thought it appropriate to. Finally, insofar as the applicant seeks any other form of relief, would dismiss the application because it fails to disclose a relief of the kind which is sought. In the result, the application for leave to
I must admit I'm not aware.
know that they'd yet come in. Just to Pham, have a
I'm going to challenge based on the fact that
of course you may, but at the moment
well, there's no
we don't
reason for me to have a look at it.
document contains an expert.
Well, I'm not going to waste my time on it.
You don't.
No, I personally on the fact that you call me irrational and out of reality, and not in reality. So
I
it's
understand you are dissatisfied, assuming for argument's sake, impose the costs separately.
yes.
All right, then we'll
But why? I'm going to challenge it anyway. It doesn't matter whether it's 3,000 or 10,000.
Ms. Hodson, a solicitor
Certainly made up on a
only seeking cost on the party, other than having been successful, of which costs of the application, the applicant shall pay. Thank you. Judge Jones, sign it after.
All stand, please. This honourable court stands adjourned. Sign. All stand, please. This honourable court stands adjourned. Sine die. God save the Queen.